President of the Senate, Ahmad Lawan, has said that a ruling by the Federal High Court in Abuja won't stop the National Assembly from amending the Electoral Act. The court, in a ruling delivered on Monday by Inyang Ekwo on an ex-parte application by the People's Democratic Party, barred the President Muhammadu Buhari, the Attorney General of the Federation, and the Senate President from tampering with the newly amended Electoral Act 2022. The court maintained that the Electoral Act, having become a valid law, could not be altered without following the due process of law. President Buhari, in a letter dated 28 February 2022, requested the National Assembly to amend the Electoral Act. He drew the attention of the chamber to the provisions of Section 84, subsection 12, which, according to him, constitutes a defect that is in conflict with extant constitutional provisions. The Senate President, while reacting to the ruling by the Federal High Court after the Electoral Act Amendment Bill scaled first reading during plenary on Tuesday, said the same violated the provisions of the 1999 Constitution as amended on separation of powers. The Senate
cannot stop us from making laws. The problem with the letter the President sent was that there was a part of it that interpreted the law. And I think that is the only part that the court can act on, because he said that the law we made is or to violate the Constitution, which is not his responsibility. And I think to that extent, the court can comment on that one, but not on the fact that we're making law.
You've raised this issue that you're aware of a pending court decision, you're aware of an order. I think the argument you have raised is valid, but this one will present in court to discharge that order. We cannot sit and appeal here on a matter that's already been given an order in court. So I think that we should exercise caution in sitting the judgment over a matter that a decision has been given, or at least an order has been given. What we need to do is to brief our lawyers to go and discharge the order, instead of sitting here and then we say that we are disobeying court order. It's not good for us, it's not good for our system. That is calling for anarchy.
The President, while giving his ruling to the order raised by Ekweremadu, said the judiciary under no circumstance can stop the legislature, the National Assembly, from performing its legislative duties.
The Constitution of the Federal Republic of Nigeria, our governance system, is based on the presidential system of government, where there's clear-cut separation of powers. And I mean separation and exercise of powers. The judiciary, under no circumstance, can stop the legislature, the National Assembly, from performing its legislative duties. We know what our due processes are. So just like we wouldn't venture into what the judiciary does, the judiciary should understand that we have our processes. If the President writes to the National Assembly to request for an amendment, that is within his competence. And it is for the National Assembly to decide whether it agrees with the request of Mr. President or not. But to say that we cannot consider it is to ask for what is not there to be given.